Dear all, today let us discuss one problem under the administrative law. Here, the problem runs like this: the municipal corporation has statutory powers to demolish any building without any notice if it was constructed without its prior permission. Ramesh constructed this house without permission. The corporation demolishes the house of Ramesh. Advise him. So, this is the problem we can see in the previous question papers of the Karnataka State Law University. Here, if we want, we can divide the facts, we can simplify the facts like this. The municipal corporation has statutory powers to demolish any building constructed without its permission. Ramesh constructed a house without obtaining prior permission from the municipal corporation. The corporation demolished the house without issuing any notice to Ramesh. So these are all the simplified facts of the above problem. Here, in order to discuss this problem, it is very much convenient. We can adopt this fire act method or IRAC method. We can simplify the facts, we can frame the issue, and we have to highlight the rule of law, and we have to analyze the entire things, that is fact, issue, rule, under the analysis part, and we have to give the conclusion. Or otherwise, we can straight away frame the issue, that is question with regard to the based on the problem and the rule provision of law, and we can analyze all these things and we can give the conclusion. So next part is framing the issue, whether the municipal corporation can demolish a building constructed without issuing any notice to the owner. So this normally certain times it happens. The administrative authorities certain times without issuing the notice, they are going to demolish the buildings of citizens. At the time, which law will prevail? Here, as per the prevailing law, the municipal authorities, they need not have to follow the procedure of giving the notice. That means in the statutory powers. That means they are having the powers under the statute or act or legislation, that they need not give the notice if a person constructs his house without getting the proper permission. But here what happened? There is one more law is there, that is natural justice. Here, this natural justice is not a judgment law. Here, this natural justice which could be followed by courts in order to secure the justice and to prevent the miscarriage of justice. No doubt there is some statute is there with regard to the not giving the notice, but whether this statute is constitutionally valid, whether the municipal corporation they can they can violate the rights of the people, whether they can deviate from the natural justice, whether they can do the miscarriage of justice. Here, as you know, this natural justice, the main intention of the natural justice is to secure the justice and prevent the miscarriage of the justice. Here, the court, the judicial review, which has to check whether the person has got the license or not, whether he has secured the the permission or not. So that aspect we have to consider it. So that will be there with regard to this problem. Here, after the problem, we have to go for the rule of law or principles of the law. Here, we have to do the principles of the natural justice. That is, here, as you know, there are certain principles of natural justice are there in this connection, and as per the principles of natural justice, certain conditions has to be followed. Here, the principle of adi alteram partem, that is the main fundamental principles of the natural justice. That means here both the sides, before passing any judgment, no man should be punished or condemned unheard. That means here municipal authorities, they have not given the opportunity for a person, so they are going to punish. They are going to punish without hearing him. So this will be against the principles of adi alteram partem. And there are two maxims are there with regard to this aspect. That means they have to give the compulsory notice and they have to do the fair hearing. If they do not follow this aspect, what will happen? Then there is a clear violation of the natural justice. So that aspect is there. In administrative law, we have to write the principle of natural justice. We have to discuss this one, and adi alteram partem, and what we call this aspect we have to discuss with the help of the relevant case laws. There are number of case laws are there in this connection. Krishna Kumar Singh versus State of Bihar, Municipal Corporation of Greater Mumbai versus M.H. Shah. Here, that aspect of giving the notice is a must. That means if they don't give the notice, it is a clear violation of the natural justice. And K.K. Balla was a state of MP also. This aspect has been upheld by the court, that unauthorized construction can be removed, but with the due process of law. At least they should have given the notice and some hearing should have been done. But here no option has been given to the person. So likewise, all these things we have to discuss under the rule of law. Then we have to discuss all those things in the analysis section. As I have told you, we have to discuss the facts of the case, issue, and the rule of law. We have to discuss all these things and we have to give our opinion. That means Ramesh can challenge the demolition action in a court of law, such as the High Court under Article 226 of the Constitution, or if it is with regard to the Supreme Court, Article 32 of the Indian Constitution, with regard to protection of his natural justice and the due process of law, and he can secure the appropriate relief.